Greetings to you all. I'm Taniya Pandey and you're watching Courts this week on LiveLaw. Every week I'm here with the most recent court updates, and if you want to stay updated with me, then subscribe to LiveLaw and click the bell icon. Let's start the episode with judgments from the Supreme Court. The Supreme Court on 26th August pulled up the Tihar Jail authorities for acting in connivance with the Chandra brothers in engaging in illegal activities by flouting the jail manual, dissipating proceedings, derailing investigation, etc. in the Unitech money laundering case. A bench of Justices D.Y. Chandrachud and M.R. Shah ordered to shift ex-Unitech promoters Sanjay Chandra and Ajay Chandra from Tihar Jail to Mumbai's Arthur Road Jail and Taloja Jail to be housed separately. The court also asked why the Commissioner Delhi Police had not taken any action after 10 days, despite the communication by the Enforcement Directorate to him making certain allegations against the jail staff. The bench directed the Commissioner to personally carry out an inquiry into the same and to submit a report within 4 weeks. The Supreme Court on 27th August directed the state of Haryana and Faridabad Municipal Corporation to file its response in the plea seeking directions to appoint a monitoring committee to look into the manner in which temporary shelter and other facilities are being provided to the residents of Khori and to present its conclusions before the court. The matter was listed before the bench of Justices A.M. Khanvilkar and Dinesh Maheshwari. Petitioners averred that despite the top court's direction and undertaking by the representatives of the respondents, the petitioners and other similarly situated persons of Khori have been living in deplorable conditions since the beginning of the demolition, and the actions of the respondents were in violation of every established procedure of law and natural justice. To ensure the uninterrupted education of children who lost either or both parents after the onset of COVID in March 2020, the Supreme Court has asked the state governments to shoulder the burden of their school fees if the private schools are unwilling to waive it. A bench of Justices L. Nageshwar Rao and Anirudh Bose underscored that the states have the obligation to facilitate the education of such children as per the mandate of Article 21A of the Constitution of India. At the same time, the bench also clarified that the assistance is meant for children in need of care and protection alone. The child welfare committees were directed to identify those children who do not need the care and protection and financial assistance from the states. While hearing a PIL regarding pendency of criminal cases against MPs and MLAs and expeditious disposal of the same by setting up of special courts, the Supreme Court has expressed deep concern at the long pendency of criminal cases and has called for the establishment of more special or CBI courts to deal with such matters. A bench of Chief Justice of India N.V. Ramana, Justice D.Y. Chandrachud and Justice Suryakant noted that it may not be humanly possible for one or two courts in a state to expedite all the trials to take up the same on day-to-day basis in terms of Section 309 CRPC. The court also directed the High Courts to send status reports to Supreme Court for further necessary action in the event of any non-cooperation by the central or state governments. The bench also expressed displeasure at the ED and CBI for not indicating the reasons for not even filing charge sheets in many cases even after 10 years. The CJI also said that in several Prevention of Money Laundering Act cases, the ED has done nothing except attaching properties. The court disagreed with the proposal to allow state governments to withdraw criminal cases against sitting and former MPs and MLAs on the ground of malicious prosecution and clarified that the sanction of the High Court is needed even to withdraw cases on grounds of malicious prosecution. The Supreme Court on 25th August set aside a Delhi High Court judgment which had directed the Delhi police to consider certain candidates for police constable selection despite their criminal cases. In this case, the selection authority had declined appointment of some candidates on the ground that they faced criminal proceedings. They approached the Central Administrative Tribunal, challenging these orders, rejecting their candidature. The Central Administrative Tribunal allowed their applications, and these orders were assailed before the High Court by the Police Department. While dismissing the writ petitions, the High Court took note of youth and age of the candidates and observed that their misdemeanor should not be taken seriously. A Supreme Court bench of Justices K.M. Joseph and S. Ravindra Bhatt took a critical view of the High Court's approach in adopting a light approach towards the criminal behavior of the candidates on the basis of their young age and rural setting. The court stressed on the fact that since selection was to the police force, which is tasked with maintaining law and order and to tackle lawlessness, there should be maximum scrutiny by the selection authorities to inspire public confidence. A 2-judge bench of the Supreme Court on 24th August referred to a 3-judge bench the appeals filed by Employees Provident Fund Organisation and Union of India, challenging the judgments of various high courts, which quashed the Employees Pension Amendment Scheme 2014. The question of referral came up when submissions were made on behalf of EPFO doubting the correctness of the Supreme Court's 2016 judgment in the R.C. Gupta case, which was delivered by a coordinate bench of 2 judges. In the R.C. Gupta case, the Supreme Court had struck down the 6-month opt-in window from 1st September 2014 for employees to continue making uncapped pension contributions. The present bench hearing the EPF appeals had wondered if it would be proper on its part to consider the issue in variance with the decision in R.C. Gupta's case. While quashing an externment order passed against a journalist, the Supreme Court observed that a person cannot be denied his fundamental right to reside anywhere in the country or to move freely throughout the country on flimsy grounds. In this case, the Deputy Commissioner of Police Zone 1, Amravati City, had passed an externment order under Section 56(1)(a)(b) of the Maharashtra Police Act 1951, directing the journalist Rehmat Khan not to enter or return to Amravati City or Amravati Rural District for a period of 1 year. The bench of Justices Indira Banerjee and V. Ramasubramanian observed that the drastic action of externment should only be taken in exceptional cases to maintain law and order in the locality and or prevent breach of public tranquility and peace. Let us now look at some judgments from the High Courts and other courts in the country. The Jammu and Kashmir High Court has recently held that letters patent appeal under Clause 12 of the letters patent is not maintainable against orders passed in proceedings for contempt, which are of interlocutory nature and does not determine any right or issue between the parties finally. Chief Justice Pankaj Mittal and Justice Sanjay Dhar remarked that intermediary and interlocutory orders passed during the course of the proceedings, which do not determine any rights or issues between the parties, cannot be said to be a judgment amenable to available jurisdiction of the division bench under Clause 12 of the letters patent. Coming to the rescue of a minor rape victim, the Allahabad High Court has constituted a medical board for carrying out a medical examination and submitting its recommendation and opinion on the feasibility of medical termination. The bench of Justices Manoj Kumar Gupta and Deepak Verma took up the matter on an oral mention made regarding the urgency of the situation. The petitioner, a rape victim, had approached the High Court through her father for a mandamus directing the respondent state to permit her to terminate her undesirable pregnancy. She relied on Explanation 1 to Subsection 2 of Section 3 of the Medical Termination of Pregnancy Act 1971 and submitted that the pregnancy has resulted in such extreme anguish to her that it constituted grave injury to her mental health. The Gujarat High Court on 27th August struck down the Gujarat Cooperative Societies Amendment Act 2019 by ruling that the legislation is unconstitutional, absurd and manifestly arbitrary and not in public interest. By way of the impugned legislation, the state could abdicate its responsibility of conducting elections of cooperative sugar factories listed under Section 74C(1)(5) of the Act. The amendment removed 13 sugar factories from the list of 343 specified cooperative societies under this section of the Act 1961. As a result, no elections were required to be conducted by the state for the said sugar factories. Rather, the amendment stipulated that the elections would be conducted by the cooperative sugar factories themselves and that no independent government officer would be appointed to oversee such elections. Hours after an IPS officer, Amitabh Thakur, was arrested on the charges of abetting the suicide of a woman and her friend who recently set themselves on fire outside the Supreme Court and succumbed to burn injuries days later, a Delhi court sent him to judicial custody till September 9th. The 24-year-old woman who was allegedly raped by Bahujan Samaj Party MP Atul Rai in 2019 succumbed to burn injuries on August 24. Her male friend, a 27-year-old Delhi University graduate, had died during treatment last week. The woman had alleged that Thakur had helped the MP Rai in harassing and threatening her to withdraw her case or to weaken it. Subsequent to this incident, the UP government had formed a 2-member probe panel to look into the allegations made by the woman. Conducting the inquiry into the matter, the panel on Friday submitted its report to the state government, and based on the same, the Lucknow police lodged an FIR against Thakur and Rai and subsequently arrested Thakur on charges of abetting the woman's suicide. A special CBI court in Kerala, presided over by Judge K. Sanil Kumar, on 27th August dismissed a private complaint seeking action against the CBI officials involved in the ISRO espionage case investigation. The complaint was filed alleging commission of offences under Sections 7, 8 and 9 of the Prevention of Corruption Act, read with Section 120B of the IPC. The complainant, S. Vijayan, pressed for either forwarding the complaint under Section 156(3) CRPC or to order a preliminary inquiry against the accused. The court analysed the complaint submitted and found that it suffered from non-revelation of certain vital information. It did not disclose when or where the public servants demanded illegal gratification, as alleged, and failed to reveal from whom such illegal gratification was received. For the reason that such crucial information was not disclosed in the complaint, it was held that the complaint lagged in disclosing a cognizable offence against the accused. That's all for this week. Thank you for being with us. I am Taniya Pandey for LiveLaw and you're watching Courts This Week. I wish you a great week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.